The Supreme Court has declined to urgently hear a special leave petition filed by six young women from Karnataka demanding that they be allowed to wear the hijab to the classroom. I'm Barkha Dutt, you're with the Mojo story. Let's take you through the key developments of this story from Karnataka that will have national consequences. The Karnataka High Court delivered a verdict that ruled that the hijab is not an essential practice of Islam. They use this finding to make the argument that a uniform is a reasonable restriction on the freedoms enshrined under Article 25 of the Constitution. Now, it is important to remember that the Karnataka High Court has offered no view on a hijab ban per se. The High Court was asked to look at whether the hijab is an essential practice under Islam and gave its verdict on that. But effectively, the Karnataka government is demanding that any overt religious symbol, including the hijab, is violative of the uniform. The young women are now looking to the Supreme Court to alter the course of what might happen to their futures. What are the points of law at play here, especially fundamental rights? And could the Supreme Court provide a middle ground to this standoff? We're joined now by Justice Deepak Gupta, who's, of course, served as a Supreme Court judge. Thank you very much, sir, for being with us again. It's always a pleasure to learn from you. Let me start by asking you whether you believe that the petitioners themselves might have made a mistake by making this about whether the hijab is an essential practice of Islam or not. We have seen from the Sabarimala judgment that that is always a minefield. The Supreme Court is revisiting its own judgment in that particular case. Do you think that has been a mistake to make the debate about what is an essential practice of one religion or the other?
Well, Barkha, I mean, going through the judgment, I just glanced through it. It's a long judgment. I haven't been able to study it in detail, been busy with other things. But from the judgment, it appears that the main challenge was that it is an essential part of Islam. Here, if this is the main challenge, yes, I would be in agreement with the Karnataka High Court that this may not be an essential part of Islam. And then again, as I've always said, personal biases matter. I am not personally in favor of hijab or any other dress which is, stops women from being as powerful as men or better than men. So in that sense, but I think there were other issues raised before the Karnataka High Court, which it has not addressed. I mean, it has just sort of skirted the issues or just brushed the message.
Let me try and understand what those issues are in a moment from now. But as we're looking at some of these key statements from the Karnataka High Court verdict, let me put to you, Justice Gupta, that maybe there was a kind of error in framing this as a debate about whether hijab is an essential Islamic practice instead of whether young women and their right to education should be put above what you think of the hijab.
Exactly. That is what I was wanting to come to. That even if it is not a fundamental, essential to Islam, let's assume that the High Court is absolutely right in that. And I probably will agree with the High Court judgment in that aspect. But if we go further, what are we doing? You see, the court, whether it's the Sabarimala case, whether it's the Triple Talaq case, or whether it is this case, the court is treading a very dangerous ground. Judges are not trained to interpret religious texts.
Yeah.
Now, what is a religious practice it's very dangerous for judges to decide what are religious practices. But there are religious beliefs which may not be essential to a religion, but which get linked to a religion. Hijab is something which is linked to Islam. Like wearing a cross is linked to Christianity. Om, whether written, it's only a Hindu would say Jai Shri Ram in the morning. See, these are practices which may not be essential to religion, but they would fall within social practices. This will fall under the freedom of expression to say something. Now here you have to draw a balance. See, it's a very debatable thing. In some people are saying it's a very progressive judgment, and I do see parts of it as progressive. But what started off as being a progressive judgment ends up being regressive. And why I say so? Because what are you doing by this? Every community, whether it's Hindus, Islam, Christian, you have a very liberal section of that society, you have a moderate section of that society, and you have a very conservative section of that society. Now, the conservative girls from conservative families were coming out to study in secular schools, getting higher education, which maybe they will stop if they're not allowed to wear the hijab.
Yeah.
I'm not supporting the hijab, but now look what you're doing. It's a very dangerous thing that the girl will not study further. If she had studied further, she would have might thrown the hijab aside herself.
Yeah.
But if you don't, because education is the greatest emancipator.
Yeah.
And if you want to
I agree with you, and I think that it's almost like double jeopardy. That if we do indeed believe that the hijab is a sign, and many people do, of gender bias, of orthodoxy, of oppression, of inequality, then why punish the girls the second time around by denying them school access on the basis of it?
you're absolutely right. You see, these are social changes which must be brought about over a period of time. You can't issue an edict that we ban the hijab from today. Effectively, what you're doing is you banning the women from coming to uh, study.
But do you think the petitioners have made a legal error in asking the court to decide this on the basis of what the Quran may or may not say? Because that is effectively what the court had to decide. So I'm very struck
No,
by the fact that you say it was parts of it are progressive, the conclusion or the outcome is regressive. Do you think that this should never have gone into whether the hijab is an essential religious practice or not?
no, I don't think so. They could have argued that, in a case you can always raise alternative pleas. And it's not as if the plea has not been raised that it is a social practice, it is, something with freedom of conscience. All these pleas have been raised, but they've been sort of brushed right that we're dealing with the main thing they said. You see, my worry with this judgment is that as if these girls were on trial. They were not.
Yeah.
You see, that is, if you are in a case deciding something which is going to have great social impact, and this judgment is going to have a social impact not only in Karnataka but the rest of the country also. Now, do you want, on one hand, we say under Article 21A, though even earlier under Article 21, the courts have always read the right of education to be part of freedom, the right to life. Now you have an Article 21A which says, yes, it is a right, maybe till 14 years, and then thereafter also. Now, if it is a right, and there's a conflict between two rights, assuming that it's not an essential part of a life, I think what should have been given, had been put on a higher pedestal is the right to education.
Absolutely.
They have a
But
right to education. Sorry.
You said something, two very important things. You said that the judgment treats the girls as if they were on trial, and you also say that the right to education should have been foregrounded. Both are very important points. But you said at the beginning that the verdict brushed aside or skirted around certain other key issues. What are those issues?
One of this is the main issue. You see, this is one of the main issues. You are deciding, even if it is, this is not a litigation, adversarial sort of litigation. You're deciding the rights. You don't have to be very technical, even if it is not directly raised this point, even if it is indirectly raised. If I was a judge, I would definitely deal with it. See, the mindset of the court when it says that uniform is essential. I agree. In schools, etc., uniform is required. But then they say, if you don't have a uniform, it leads to
Public disorder. There's a talk about
public disorder
it's
is
in a separate
mind-boggling.
part. Yeah.
No, I find it mind-boggling how could if two people come in different dresses, how does it become a public disorder thing? Public disorder is not in the dress. Public disorder is in the minds of those. That leads to public disorder who cannot tolerate a particular type of dress. You see, you can't put the culprits on a pedestal and the victims are made to face trial. It's basically like that. They came to court saying that maybe that should not have been the main argument. Maybe the religious belief is such that that was the main argument, that it is the essential part of a religion. Assuming that is not correct, I personally would agree that it may or may not be. I've not studied this in very great detail. But I'm surprised that this High Court relies upon the opening lines in the from a young girl's school dissertation where she described what the hijab is. That's where the judgment starts from. We need something much greater depth to understand what is the hijab. As I said, I am not in favor of the hijab. But we have to face it that hijab today is almost linked to Islam. And it's not only in Islam.
But maybe not at the level of religion, but at the level of culture or social practice, as you said, or identity issues for a younger generation.
Yeah, identity issues. I mean, and it's the world over. And hijab is being worn, I think, other than France, which totally says no. Almost all other countries tolerate or allow the hijab. Why say tolerate, but allow the hijab.
Yeah. Let me ask you this.
Especially in schools.
The lawyers for the legal team for the petitioners has argued that there should not have been this binary and that the court ignored this right to conscience while deciding on this. Can you explain for a lay person audience what this right to conscience is?
See, Barkha, I'm sorry, but I have on my table the preamble to the Constitution. I've always kept it on my table since I became a judge. Because for me, the heart and soul of our Constitution is in the preamble. Now, I'll just read you 3-4 lines from it's a very simple language, even a lay person can understand. And I think I will have to say nothing more. I mean, we constitute ourselves into a republic to secure to all its citizens justice. First of all is justice. What sort of justice? Social. We're talking of social justice, economic justice, and political justice. Number 2, liberty of thought, expression, belief, faith, and worship. I mean, when you talk of faith and worship and expression in India secularism, an atheist has as much right to express his point of view as the most religious person. They have a right to debate as long as the debate is peaceful. Equality of status and opportunity. But again, I'm coming to the last. And to promote amongst them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Now, I think this is a complete answer to the High Court judgment.
Yeah.
It goes against everything which is enshrined in the preamble. We are now leading to a state where there will not be fraternity, but people will be fighting with each other, and this is how it started. I don't know whether this order was 10 years old or 15 years old, but girls were going in their hijab.
Let me ask you this: what have we though learned from the Sabarimala case, right? Because there the argument was a little different. The argument there was women believe that menstruating women should not be discriminated against. The court once again took this line that that this demand was not counterintuitive to essential practice, and then the backlash from people, including women, who have obviously been culturally shaped, or large sections of them have been culturally shaped to believe a certain way, has now led to the Supreme Court reviewing its own verdict. What does this teach us about the courts getting involved in these matters?
See, and interestingly, the dissenting judgment in the main Sabarimala case was by Justice Indu Malhotra.
Yes.
Huh?
Yes.
But I tend to agree with her to a certain extent that what is the role of courts in these matters? See, one is we may think this is a right practice or a wrong practice, but should courts enter this domain of what is a religious practice or an essential religious practice? Practices evolve over a period of time. Especially in Hinduism, many practices would have evolved over a period of time. A married lady in North India especially would wear a bindi or sindoor. a married lady in South India or most of the country would wear a Mangal Sutra. Now, I don't imagine the Karnataka government is going to stop any married Hindu woman over the age of 18 if she goes to college, even which has a uniform, wearing a bindi or a Mangal Sutra.
Yeah.
A Christian wearing a cross. We've lived with Sikhs. We in India have lived, especially in North India, we've lived with Sikh boys and girls and Sikh boys especially come to court in their turbans. What sort of dissension has it created? Nothing. It was true that it may be an essential part of the religion, but has not created any dissension. I thought we should have learned from that we can all live together with different dresses.
Yeah, but what I'm hearing you say is that the court should not actually get into the matter of what is essential religious practice, because religion is interpretative, it's personal, and it keeps changing. Who is a court? It can't remain frozen in time. What's an essential religious practice?
I mean, what is Hinduism? If you look at the old Vedic era, then I mean, I'll just give to Swami Dayanand Saraswati, who brought in Arya Samaj. And if today's date, Barkha, if he had said that I don't believe in idols and smashed the idol because he'd seen a mouse eating the prasad around the idol, he would have been sent behind bars and probably sedition charges would have been put against him. See, we're becoming intolerant.
Yeah.
We're not willing to listen to the other point of view. As I said, personally, I'm against the hijab. But if somebody believes very strongly that I will not go to school or college if I'm not allowed to wear the hijab, then I think we should let them have that latitude, let them be educated so that they themselves can give up the hijab.
Yeah. Can I ask you? Sorry. Go ahead. Go
Can I
ahead.
just add?
Yeah.
I think we're treading on very dangerous ground. And what is happening now is that these children who wanted to come to school are being turned towards that section of society where it is conservative, maybe towards fundamentalism also. So what is essentially happening, you converting people who are moderate, may not be liberal, but who are moderate, who want to become modern and liberal, you're telling them, no, we will not allow you in our schools unless you give up this hijab. Is it such a dangerous thing? I could have imagined if it was something which would create a dissension in society. Yes, fair enough. Back. It doesn't create a law and order problem. It is not against the sovereignty of the country. How does it matter? It is not immoral.
What is the principle that the Supreme Court will now have to tackle? Will the Supreme Court stick with the essential practice argument, or will the Supreme Court also look at individual fundamental rights like right to equality, right to life and personal liberty, and so on?
Not only there will be other issues also. First of all, as far as the essential practice argument is concerned, the Sabarimala judgment is already before a 7-judge bench under review. We don't know what will happen, because I'm saying this is something which is, even I can't give an opinion very one way or the other till you hear the points, arguments on both sides. But I believe that even if the court has the right to interfere, it should exercise restraint and not interfere unless the practice is so malicious that it is totally not suitable. It can't be accepted at all.
But what do you mean that the Supreme Court should not interfere? What does that mean?
No, I should said it should normally not interfere. It should exercise restraint while dealing with what is a religious practice at all. Because we are not trained. I mean, with all due respect, these 3 judges, out of them, one lady was a Muslim, so I can't. But the other 2, I mean, in 1 month you can't learn the Quran. Or over a period of arguments over 11 days and another 1 month, you can't learn the Quran.
And by the way, every Muslim I've spoken to has a different opinion on where the hijab's place is in Islam. So it's interpretative, and
it may not be. As I said earlier, I am not even certain whether it's an essential part of Islam. Now let's take it closer home. For Sikh women, keeping kesh is an essential part of religion, but I've hardly seen a very minuscule portion who wear a turban.
Yeah.
Now, if that is not an essential part, let's say it's a part which, some people who take Amrit or something, they should believe that they should wear the turban. it doesn't become an essential part. Then what do? You stop that girl from coming to school. I'll give you another example. A Hindu boy, if he has a tilak on his head, it is not an essential part of our religion. He has a bodhi, which is not an essential part of our religion. These are practices which have developed over a period of time. You don't stop people from studying. You see, this is
What
where
would
the
you
court
what would you say? What would you say to those who say that a uniform is a very essential part of institutions, in particular schools?
I'm in school, yes, uniforms. I think I also agree that there should be uniforms in school. But uniform means uniformity. It does not mean uniformity to the extent that there is no difference at all. You see, I mean, as I gave the example earlier, Sikh boys wear turbans or patkas when they're younger. Did it create any problem? It never created any problem. And it's, we lose sight of the fact that earlier very few Muslim girls were studying. And if they came to study to college, they already belonged to families which were very progressive, and so they did not wear the hijab. Now these girls want to come to school, they'll come to school, and maybe if it's an all-girls school, they can be asked to take off the hijab inside the classroom. If it's not I can't give you all answers, but a balance must be struck. You see, balance must be struck.
And it's important to underline that contrary to what has been reported in the media, the Karnataka High Court has not upheld the ban on the hijab. It has merely said that the hijab is not an essential practice, right?
Yes.
The two things are very different. The media is going on reporting that a ban has been upheld. Tomorrow, if a Karnataka college decides to make the hijab part of the uniform, the Karnataka High Court does not contradict that in any way.
But Barkha, with all due respect, when you read the entire judgment as a whole, they've virtually said, and the wording of the Karnataka government order.
Yes.
That hijab, are we going the French way? There one way to look at things is like we go like France have gone, that you ban anything which is a religious symbol. But if you don't ban all religious symbols, you can't choose one. Now the court accepts it's a religious symbol. It's not an essential part of Islam, but it is a religious symbol. In a sense, the court is saying that it's a religious symbol. Because it is identified with this religion.
Let me ask you finally, sir, what would you hope the Supreme Court does with this petition?
I hope, one, that they hear this petition as early as possible. Because one, this is a petition which should not hang fire for a long time, because it will lead to fire all over the country. I hope they deal. And I hope they take a view. You see, as I said, with what I started, that a progressive judgment starting in certain ways, but the end result is aggressive, that is, children are prevented from studying. It's very easy to say, we will not stop them from studying. It's the parents who are not letting them go. But we're talking about 15, 16, 17-year-old girls who will do what their parents tell. They have to live in the house. So we have to protect the girl child. We have to not only protect her, we have to encourage her to go out and study. And even if it be a little variation in the uniform, if the Kendriya Vidyalayas can allow the hijab to be worn, they're also central government, but the High Court brushes that aside, that central government is one and the state government is other. Legally may be right, I'm not talking. But when you decide a case with legal issues, but social impact, you must take into effect what is going to be you must take into consideration what is going to be the effect, the social impact of your work.
Absolutely. Justice Gupta, thank you. And you're absolutely right. There's a letter of the law and the spirit of the law, as the old cliche goes. And this has far-reaching consequences for the rights of girls to study and get an education and get emancipated, to make choices that are more free and less socialized. Thank you, Justice Gupta. Always a pleasure. Take care. And thank you very much.
Thank you so much. Thank you.
Bye, sir.
Thank you.
It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.